Good afternoon. Welcome to the third part of the OFIS Winter Webinar Series on safe and accepting schools and developing policies around school safety. Franklin, I can't seem to move my screen now.
Just click the arrow button if you want to change slides.
Not working. Hang on. Oh, there we go. Thank you.
No problem.
Okay. Thanks a lot. It's a crazy way to get started. So just want to start with an idea that safety issues arise all the time, and that it is important to review safety policies at schools regularly, just because there are always things that come up that we can't quite seem to anticipate. And it also gives greater emphasis sometimes from a school culture perspective about addressing an issue. And I just wanted to use as an example the recent story, the tragic story about the kindergarten student who had been picked up from school and was inadvertently crushed between two cars. And so I've given you the link to the article there and some important points. The article referenced a growing concern about distracted drivers, which is a big issue in general, and there's been lots of new, even provincial legislation around dealing with distracted drivers, but that's also becoming an issue at schools with respect to dropping off and picking up students. And so the principal, after this happened at their school, came out right away with some communication to parents about changes to policies and about how to make school grounds safer for families. And so I've given you some of the details there about what was in those emails and about some of those policy changes. And what the principal said was really, I think, says it all kind of in a nutshell when it comes to addressing school safety issues and about regularly keeping policies up to date. He said, accidents happen in the blink of an eye, and I think it's forced us to go back and take a look at our practices to make sure that we're doing the best we possibly can. Regrettably, it could happen anywhere, and that's really the truth. It can happen anywhere. And so when we hear stories like this in the news, it gives us, again, a renewed energy into having a look at our school safety policies and being sure that everything we want to have in there is indeed in there. So, a general rule of thumb about reporting protocols, because that's the first thing we're going to address today. It's important to keep an internal report on every incident, every single incident, in addition to external reports that are required and some that may be required. And I've given you a list there of circumstances where you would need to make internal reports to keep on file at your schools, but also where you might have to submit external reports. And those external reports may be part of a legislation requirement. Sometimes they would be Ministry of Labor or Ministry of Education. But sometimes they may be requested by police, or they may be requested by other legal agents with respect to court cases and with respect to lawsuits. Unfortunately, those are reasons why you may have to hand on external reports as well. So there's the list for you. The biggest question about incident reporting that I get at the OFIS office is, when do you bring in the police? So I've given you some tips here. So there are three kinds of categories. There are incidents, including attempts, that result in a mandatory or involvement or response with the police. Those are things that potentially could lead to suspension or expulsion. Incidents, including attempts, that result in a discretionary call to police or potential police involvement. And then the third category is incidents, including attempts that result in police consultation. So this is the list of all issues that are mandatory to report to police if they happen in and around your school grounds and in your school activities. It's quite a list there. Those are the things that you are required to report on to police. Some of those things aren't 911 calls, they're calls to the regular police line, but they do all need to be reported. So in mandatory police reporting, the police are to be notified once the details of the incident have been validated by the school principal. You have to contact the police no matter what the age is of the students involved in the incident. I've gotten that question a lot in the Oak's office. Mandatory police reporting does not mean that the police will lay charges in every situation, but they must be notified, and it's their decision. Incidents include those that happen at school-related activities that are in or outside the school, or in any circumstances if the incident would have a negative impact on the school climate. So that gives you an idea as to, I get a lot of questions about, well, the incident happened you know, at another student's home or so forth. And this is the three sort of filters that you can use. It either happens at the school, it happens at a school activity, in or outside of the school, or it is in a circumstance where the incident may have a negative impact on the school climate. So discretionary police reporting, this is the list of incidents where you may call the police. You may decide to just use the school policy that you have in place already. Perhaps you don't have a school policy that covers all of these kinds of incidents, but you can call the police, and it's up to you if you need to call the police. In a discretionary situation, the principal should consider mitigating factors to decide whether or not to call the police in these situations. You're asked to use good judgment. All other school-related occurrences that are not specified in this list could be dealt with by the principal and by policy, and the police could be notified at the principal's discretion. And if you're going to consider calling the police to consult them about whether or not what you need to do and whether or not a report needs to be made and so forth, these are this is the list of considerations, let's call it that, the list of considerations in making the decision about whether or not you need to consult the police. So consider the type of incident and whether you have adequate resources at your school available to deal with it. Consider the degree of harm that may have happened. Consider any previously recorded occurrences. Is there a pattern here? Consider incidents that occur off school property, which could affect other incidents at school. Consider the age and the personal history of the individuals that are involved. Consider the attitude of the individual and his or her willingness to repair any harm that may have happened. Consider input of any victims that may be involved. And consider incidences involving a suspected breach of any federal, provincial, or municipal legislation. Remember that the police are a community service. They are there to uphold the law, but they're a community service. They have school resource officers whose jobs it is specifically to help schools handle these kinds of incidences that happen on site and around their activities. So when you have to share information, when you have to make incident reports, what kind of rules or what kind of legislation binds sharing and the disclosure of information? There's a number of statutes that apply in those situations, and it's important to remember that where federal and provincial laws are in conflict with each other, the federal law always takes place. So I've given you there the pieces of legislation that are relevant when considering information sharing and the disclosure of information with respect to information you have at your school. So let's start with the Youth Criminal Justice Act, the YCJA. I've given you there two specific references from the legislation that involve the disclosure and sharing of information. So the principal or any other person shall share information that has been disclosed in relation to a youth, shall keep the information separate from any other, I can't read this, sorry. Oh, back one. Ensure that no person not authorized by the YCJA has access to that information, and to destroy the information once it is no longer required for the purpose for which it was disclosed. And then subsection 110.1, no person shall publish the name of a young person or any information that would identify that young person dealt with under the YCJA. And there are two more. No person shall publish the name of a child or a youth or any other information to a child or youth, young person if it would identify as them having been a victim of or having appeared as a witness in an offense committed or alleged to have been committed by a young person. In subsection 118, no person shall be given information or record in the record shall be given where to do so would identify the young person as having been dealt with under the YCJA. Bullying can be a traumatic experience, and some forms of bullying can even be considered illegal. So you can see that there is an obligation there to protect certain information and to share certain information, but also not to share certain information even in your school if it is a matter that's being dealt with by the YCJA. The second piece of legislation is the Child and Family Services Act. This was also referenced in our first webinar around the duty to report, and that school staff must act promptly for the protection of youth that are in their care, children, in reporting reasonable grounds to suspect that a child may be in need of protection. And as was stated in the first webinar, it is important to remember that there just needs to be reasonable grounds. It's your job to report it and to make the report on it, but it's not necessarily your job to make the decision about what should be done with that. That's the job of Child and Family Services. Okay, and this gives you some insight into the criminal code that the police are allowed to access the student's Ontario student record with a warrant or a subpoena or with the written consent of the student or the parent or the caregiver if the student's over 18, sorry. And there are some circumstances, and I've referenced them there under the subsection, where a student's OSR could be accessed without a warrant. Those are very rare situations. So if the police do request to see a student's OSR, it is important to remember that they should have a warrant or subpoena or permission, written permission to show you that you are allowed to share that information. So the Municipal Freedom of Information and Privacy Privacy Act is another one that regulates the collection and disclosure of personal information not related to the Youth Criminal and Justice Act. So the school will provide the information, the police with information if they are involved in an investigation. They will, to as much extent as possible, tell you why they are asking for the information. To facilitate a police investigation, the principal will share a student's personal information, and it says there what you're allowed to share and what you're not, and that you have to share that information regardless of whether the student is at school or not, and that while the investigation is ongoing, the principal will not divulge that the information has been shared to the student or anyone else unless required by law and permitted by the police. So this is a relationship between the school then and the police, and doesn't involve the parents and the family. So when you do need to report to the police, here are some tips about that. There are some incidences that you know now require responsibility to report to police. It was the mandatory list I provided earlier. School staff, students, and parents and guardians are responsible to report to the principal any knowledge they have of dangerous or violent situations that could affect the peace and well-being of the school. I know that if you listen to the news today, they're talking about the school shooting in Florida, and that has sort of been the mantra of all police officers and the principal and anybody who's speaking on behalf of that school today. There's really a shared responsibility that when members of a school community have information about a dangerous situation that could affect the school community, there is an obligation to report that. Emergencies obviously require a 911 call. and that should be reflected in any emergency and crisis response policies or plans that you have in place. That's going to be covered in next week's webinar. And that non-emergencies, or if you have a doubt about whether or not police involvement is required, principals can consult with the Police Community Services Director in a non-911 call. So also, reports of violent incidences leading to suspension or expulsion, those must be maintained in the student's OSR. I know that we've had conversations, I've had that question a lot at the OPIS office as well. And then finally, reports to the police do not preclude the necessity and legal duty to report, especially where it's pertaining to the Child and Family Services Act. The teacher's responsibility, the legal duty to report still applies even if reports are made to the police otherwise. So about developing incident reporting forms, having the right forms on hand to use. One of the questions I get the most often is, can't we develop a general incident reporting form that could cover all types of incidents that may take place at our school? And it is a challenge. I have thought about that an awful lot. I've even dabbled in developing a draft or a template of such a general incident reporting form. And because of the different kinds of information that is required for different incidents that come up at a school, such as was listed a few slides earlier, it is a really tough thing. I've provided for you a number of templates that are available in the Basecamp. If you had a chance to look at those ahead of time, or if you, well, you'll obviously have a chance to look at them afterwards, you'll see that I've provided a number of templates in there that can provide good solid foundation for you developing your own incident reporting forms. You have to remember that there's a certain number of things that are involved in all kinds of incident reporting though, and that's what I wanted to get at here and list here. So the names of all the parties involved with the incident, and particularly to identify any witnesses and who is making the report, who is the reporter. Obviously the date of the incident is important, and the date the report is made is important. And those two dates should not ever be more than 48 hours apart. There should be obviously a detailed description of the incident, as many details as possible. There should be details of emergency services and parental contacts that were made, who was called, who was informed, and what was done with those contacts once they were made. Signatures are obviously really important on any incident reporting form. You're going to want to get parents to sign off, staff members who are involved to sign off, and students if it's applicable. Depending on what the incident is, it could be over the age of 16 or over the age of 18. If it's a discipline sort of situation, and whatever your school policy states, it may even be students who are younger. I've seen that be as low as 12. Follow-up details. You have to keep your file current. So if there's follow-up activities that are applied to any of the incidents that have taken place at the school, you need to follow up with the reporting as well. And obviously you want to keep copies. Copies of certain incidents have to go in the OSR. Copies of certain incidents have to be reported to the Ministry of Labor, and copies of certain incidences would have to be provided to the police upon request, as was outlined earlier. I want to move on now to data protection and confidentiality protocols. So we've talked a bit about incident reporting. We've talked a bit about the importance of developing policy around which incidents are going to be reported, how, and what kinds of forms you're going to use. You've also been alerted to legislation that really monitors what kind of information you're allowed to disclose and under what circumstances. So we also want to take a look at data protection and confidentiality protocols, with making sure that your information is safe and making sure that it's shared appropriately. We hear in the news regular stories about privacy breaches. There is a lot of concern, public concern, about protection of personal information. And while technology has made the collection and the use of personal information a lot easier, it's also made the abuse of that information a lot easier. Identity theft is among one of the fastest growing crimes in the world. We hear about it all the time, and we're reminded to personally be vigilant about identity theft. Legislation in Ontario is always changing in order to protect personal information, and schools have an equal obligation to update their procedures regularly to comply with any new laws and any new regulations concerning the collection, storage, and the use of personal information about their students. Obviously, the ultimate task of protecting students' privacy rests with teachers. They are the keepers of a huge trove of personal information about students and their families. And teachers in Ontario need to be very aware of what their rights, obligations, and liabilities are when handling confidential data about students. Again, the MFIPPA, which is the Municipal Freedom of Information and Protection of Privacy Act, it defines personal information as any recorded information about an identifiable individual. Data such as name, address, ethnic background, blood type, fingerprints are all considered personal information. It also includes employment or criminal history, financial dealings, and health records. All of that is what's considered personal information. And unless explicit consent is given to disclose it, personal information is to be kept secret. The Education Act gives schools the authority to collect a lot of personal information about students when they register, and simply by registering your kids in school, it's implied that a family is consenting to that information being collected. It's when the information has to be shared with others that problems can arise. There are some good basic rules to follow, however. Here they are. 7 virtues of privacy protection, I call them. Collect only as much personal information as you need to do your job. Collect information directly from individuals or for students under 18 directly from parents or guardians, not from any third parties. Get consent from students or for students under 18 from parents for the collection, storage, and use of personal information. Typically, that's something that's included in a registration form annually. 5, make sure you store that personal information securely. Keep hard copies under lock and key in a locked filing cabinet. Keep electronic documents on password-protected computers. A clean desk will help prevent sensitive information from being misplaced or stolen. And when in doubt, ask for advice from the school principal or the board staff member who is in charge of privacy. What you may not realize, because it's been some time since the privacy legislation came into act, that actually Ontario law requires every board or school to have a contact person for privacy protection. So that's the reason I've highlighted that too, because that may be something that has been missed in the time since that legislation has passed. And finally, when you no longer need the personal information to do the job, destroy it by shredding paper documents or securely erasing electronic ones. So the OSR has been mentioned quite a bit already. You will find specific reference to the OSRs in federal and provincial legislation. And so I just wanted to spend a bit of time talking about the OSR. So the OSR is a good place to start in considering how student information is to be treated, because that's where we keep most of it. As you know, each OSR includes an index card with the student number, the name, the address, the phone number, gender, birth date, any enrollment and transfer dates, names of parents or guardians or both, emergency contact numbers. The OSR can also includes report cards and an official student transcript. Now, some of this information may be duplicated elsewhere or be available to teachers in other forms, but the OSR itself, the official OSR itself, and all of the information in it is to be kept strictly confidential by schools. Students themselves at any age, these are the guidelines around OSR use. Students themselves at any age have the right to access their OSR, as do their parents if they're under 18. Teachers and school officials also have fairly broad access to OSRs. They're allowed to access a student's OSR for the purposes of improving that student's instruction. It's a pretty broad term, the improvement of instruction. That comes directly from the Education Act, and there are many occasions when it's perfectly appropriate to access an OSR, but it's not always appropriate. I'm going to talk a little bit more about that later. There are other limited disclosures of information from the OSR that are sometimes permitted, such as complying with a court order in a civil lawsuit, or under federal criminal code, or under the Child and Family Services Act. But even in these cases, principals are advised by the Ministry of Education to consult with legal before turning over any records. And remember that teachers are still required to disclose suspicion of neglect or abuse to the Children's Aid Society under the Child and Family Services Act. Just some professional ethics around the confidentiality of information and the protection of data. Purposely, and I've highlighted that word on purpose, so purposely disclosing personal information can result in a fine of up to $5,000 under MFIPPA. Purposely breaching privacy is a rare occurrence, though. Most privacy breaches are accidental. Nonetheless, parents could sue a school for breaching their child's privacy if they believe that personal information was disclosed and resulted in damages. And that's the reason why we want strong policies, consistent compliance with these policies, and very consistent, accurate reporting. Just record. If staff was acting in the course of duty when a breach occurred, he or she could potentially also be covered by schools insurance, directors and officers, and errors and omissions insurance. Breaching a student's privacy without the student or parent's consent, if the disclosure is not required by law, can also result in a finding of professional misconduct with the Ontario College of Teachers. Okay, so one way to think of it is that individuals own all their personal information, all the information about themselves. When students enroll, they lend that information to the school. But ultimately, the information still belongs to them, and only the owner of that information is allowed to decide when, where, and how it will be used. There's lots of other personal information besides what's found in the OSR. Teachers are given, they're privy to personal details about their students just by virtue of sharing a classroom with them for many hours each week. They take notes about students in class to help them recall important details later, maybe to talk to parents or to talk to the principal. Permission slips require parents' names and phone numbers. Even calendars and day planners and lesson planners may contain personal information about students, things such as email addresses or phone numbers. All of that is for the teacher to safeguard. They have a duty to do so. And like the data in the OSR, this information is considered strictly confidential and only shared under certain circumstances. So you have to use good judgment. Consider whether disclosing the information that you are considering disclosing will actually result in improved instruction for the student. Privacy regulations can't make that decision for you. This is where the law steps back and professional ethics takes center stage in judging just what information sharing will actually produce or improve the education of a student and when it won't. And professional ethical standards provide guidance. This is a really good thing also to include regularly in teacher orientation or in-service days, the importance of applying good professional ethics and using good judgment when it comes to the protection of data and the confidentiality of student information. I wanted to give you an example here just so that you can see the difference between when sharing information might be positive and when it might not be. So if Fatima's parents are getting a divorce, her marks are slipping as a result, sharing that information in the staff room with a colleague so that she can get extra help and support will improve her education. Sharing that same information with the same colleague, but this time maybe in the produce aisle at the grocery store, is unlikely to meet those professional standards and wouldn't necessarily improve the education. So considering whether disclosing information will result in improved instruction is a really good benchmark. So to share or not to share, that's the question. And common sense usually provides the answer. But in case it doesn't, Nancy Massey, who is the chair of the Freedom of Information Records Management Committee of the Ontario Association of School Business Officials and Assistant Manager Records Management, she has the longest title in history, I think. She's with the York Region District School Board. She says teachers should be alert but not feel paranoid. This is what she says. I think that teachers intuitively know how to protect the privacy of the information they collect. They may not know the particulars of the legislation, but out of pure respect and ethical instinct, they do, for the most part, the right thing. When in doubt, she says that asking the school principal is a good place to start. I always recommend to teachers to err on the side of caution. Say no first and then figure it out afterwards, because once you've let personal information out, you can't get it back. There are four sort of guiding standards within the Ontario College of Teachers with respect to ethical standards in the teaching profession. Care, respect, trust, and integrity. And that should be a good starting place for all teachers, regardless of whether or not they are members of the college. Also, the Ontario Privacy Commission can provide a good roster of privacy experts for any questions that staff might have about whether they ought to divulge something or not. And schools can also put these experts to address issues of privacy for staff and for students. And OPUS can also provide many policy templates, as I've referenced earlier in the webinar. There are Basecamp, and we can review policy drafts for members to help them tighten these things up. And we also can perform school management reviews every 5 years, where we assess the operations of a school with respect to privacy and procedures. We can give some insight into gaps that may exist that could be addressed. Okay, let's move on to information technology use and social media. So schools have to address the appropriate, responsible, and acceptable use of the school's information technology resources, also by way of policy protocols. This is particularly around the kind of policy that needs to be developed for use of information technology in a school. The purpose of your policy should be to detail the acceptable use of those resources for the protection of all parties involved. And there's a list of the stakeholder groups that you should consider when developing this policy. And here is the legislative context for developing information technology use policies as well. Some of those I've mentioned before already. So when developing this policy, I've given you a list of responsibilities for each stakeholder group that exists at your school, and who should do what and who should be responsible for what when you develop your information technology use policy. So you can read that more on your own. I want to make sure that I leave time for questions, but I've listed out the responsibilities for each stakeholder group from the earlier slide. And there they are. So just make sure that all of those things are referenced in the policy that you develop. You also, in the policy, want to make sure that you name irresponsible and unethical use of technology, information technology in your school. And so I've provided the list as accurately and as completely as possible for what should be included in irresponsible and unethical use. And it should be named. You should name it as completely as possible in the policy. And you may have to add to this list over time because, as you know, hackers and other folks are always looking for ways to get around and behind and in from the back when it comes to information technology use. quite a list. So you also want to include any disclaimers, things that the school isn't going to be responsible for when it comes to the use of technology, information technology in your school. And again, as you are for what is considered to be unethical use, you also want to make a list of what you're not going to be responsible for and name that. And again, it's going to be something that you may want to redefine over time as you come up with, or as you learn of things that you don't want your school to be responsible for when it comes to the use of information technology at your school. Okay, so the next slide is about the procedural responsibilities that would flow out of the policy that you would develop. So you have listed the responsibilities within the policy, but then these are the procedural responsibilities. Who's going to do what when it comes to safekeeping the information technology use at your school or around your school activities? I thought two of those noted in red on this first slide of responsibilities, only because there is a bit of an ongoing debate about this particular issue. I am suggesting, or OPUS is suggesting, that schools make it a procedural responsibility to not accept donated computers. There is a whole lot of issues around accepting donated computers and making sure that they are safe and making sure that they are password protected, and making sure that they don't have any other pieces of software on them that may make them susceptible or vulnerable. It's very difficult to license and manage and secure those types of computers. And you would have to obviously add a rule in there to apply disciplinary measures for anyone who did bring in a donated computer or used a computer that was not designated by the school. It's in red because it doesn't have to be included. It's a matter of judgment. It's a matter of decision about whether you want to do that in your school or not. And so I just wanted to highlight that. There's, again, the procedural responsibilities for each of the groups, each of the stakeholder groups in the school. Sometimes IT staff is principal, and I know in our smaller schools that's especially true, but I would suggest too that that be someone separate from the principal, just with respect to making sure that there are two people who have conversations about what the procedural and policy responsibilities are going to be around information technology use. And that's the last group. I just wanted to spend a few minutes talking about the use of non-school devices, or the new program of bring your own device. I know that a lot of the public school boards have gone this direction, and it changes, while many pieces of the information technology use policy and procedures would still be the same. There would be some differences around there would be some additional differences around what policy and procedural parameters would be. And I do have a good list of what those would be, and you just need to contact the office. If your school is considering a BYOD program and wants to make sure that the policy and procedures they develop around that would be safe for the school. Okay, so we're going to spend the last part of this time talking about social media and code of conduct. And we're going to spend the last few minutes of this webinar talking about the connection between those two policies that you would have in your school. It's really important to fully reference social media expectations in your information use technology use policy. When you have a chance to read through those other slides and through the materials that are in Basecamp, you will see that in the expectations, the policy expectations, and in the procedural expectations, I have fully referenced the use of social media in the information technology use policy. And it's really important to fully reference those together. Fully reference social media expectations as well in your school code of conduct. Tie them together. Any behavior online should be synonymous with behavior offline, and the consequences should be the same. Any kinds of consequences around behavior and progressive discipline should be the same, whether the behavior has happened online or offline. And I know in webinar 1 we talked about that as well with respect to bullying prevention and intervention. But cyberbullying is to be considered the same as bullying, physical bullying. Detail what to share and what not to share. Consider personal safety, school information, make sure all of those things. If you are going to develop a separate social media policy, that all of those things are detailed in there. Make sure that you give cautions about images and what can be shared and what can't be shared, whether it's a school protected image and what bank of images could be used, and when parents and maybe talking about their school online through social media, other sites, pop-ups, and when mistakes are made and how corrections are made. I already talked a little bit about cyberbullying and how that needs to be referenced as an actual piece of bullying that the school does have a plan in place for, and a set of policies around and consequences around, and what will happen if those things are violated. And if you do decide to develop a specific social media policy, obviously you're going to want to make sure, as with the code of conduct, I still recommend that you fully reference your social media expectations with your information technology use policy as well as your code of conduct, but make sure that parents or students who are over 18 acknowledge that they have received it, that they've read it, and they agree to it, and that you get signatures annually. There are some good social media policy resources or social media practice resources. One of those is the Ontario College of Teachers Social Media Advisory, and the link is here. That's why it's highlighted and underlined. There is a sample social media policy in Basecamp if you decide to develop one separate from the information technology use policy. And I developed a whole list of social media protocols which would be applicable and relevant for all members of a school community. That list is also in Basecamp. It would make a great learning opportunity for older students, but it would also make a great staff opportunity for an in-service. And of course, it provides really good protocols for developing a social media policy if you would decide to go that route. Okay, so we are at 1:42. And it is time for questions. I want to thank you for listening in this afternoon. I know it was a lot of information to absorb. I also know that the whole set of rules and professional expectations and ethical standards around the use of information and the sharing of information and the disclosing of information is one that we have not done a lot of work on at Opus, and given the fact that so much more is happening online, you're even learning online today, we need to make sure that we provide more resources to our schools and really help them develop good, safe policies as part of their entire school safety package. We need to provide more resources here. So we may find that this comes up again in other workshops. We may also find that schools are starting to request assistance in having Opus help them develop those policies, and all of those things are things that we will consider. It's a big topic. It's hard to do it justice in 45 minutes in one webinar, and I am certain it's going to come up again. So at this point, I'd be happy to take questions if you would like.
Thank you again, Barbara. I see we do have questions. Would you like me to
read
them out to you so that you can?
I am looking at
Great.
Okay, so we have a question. I'm going to get through these as quickly as I possibly can. I do have all of the people here who are asking the questions as well, so I can follow up afterwards, or these people are welcome to contact me at the office as well. So somebody says here, minor infractions, etc., are they considered incidences? would you need to do a report? I'm not really sure what, I think the whole phrase minor infraction may be in the eye of the beholder. I gave you in the slides, in the presentation, two sort of lists of what has to be reported and another list of what is discretionary. I would say regardless of whether or not you have to inform the police, you need to keep track of every incident, and I would say over-report rather than under-report. So any incident where any sort of consequence is applied or any sort of action is taken, there should be an incident report. So I hope that answers the question. Let's see here. In a case where a reference form was filled out for a student by another school, and this form stated that the information will remain private, if parents ask to see this reference form, is it considered the property of the school or of the parent? Let me just make sure I understand this correctly. In a case where a reference form was filled out for a student by another school, and this form stated that the information... So I'm going to say that if the reference form was filled out for a student and it was given to another school by another school, that is actually the property of the school. It is about the student. It is the property of the school. And so, yeah, I would say that is probably not part. I'm not even sure whether you would put that in the OSR or not. You may want to keep that in a different file. I know that schools often have files, OSR files, but they also have student files, and this may be something that you wanted to keep in a student file because it's not part of the required reporting. And not every school does reference forms, and it would depend, I guess, what the purpose of the reference form was. Hopefully that answers the question. That person is welcome to contact me afterwards if they need more clarification or if they want to tell me more about what the specific situation is. The next question is, if a student uses a teacher's device, tablet, computer, but also has private information stored on it, marks, emails between teachers and parents, which can be accessed without a passcode, can students use the device? Well, they can, but they shouldn't, is the answer to that question. That is just opening the school up to a legal vulnerability, but also an ethical vulnerability. Absolutely, any devices that students use should be student ready, and not only should students not have access to marks and emails between teachers and parents, nobody should have that information at all, except the teacher who's using it, and the teacher should do everything that they can to make sure that that information is guarded and private. Next question is, if a teacher uses their own computer and brings it into any school, is there any issue? My suggestion is that if a teacher is going to use their own computer and bring it into the school, that is basically a bring your own device sort of scenario, and would require the development of a bring your own device policy. And as I said in the webinar, I actually have an entire list of both policy responsibilities and procedural responsibilities that you could use to develop that kind of policy so that the teacher using their own computer as well as the school and its information and the students' information are all protected. So I'd be happy to share that if that person would like to contact the office and get it. And that's all the questions that are in here at the moment. Do we have any other questions? Feel free to put in. You could also feel free, if you would like to, if it's not a question, if you have a topic around this sort of bank of information around information sharing and disclosing, confidentiality, social media protocols, all of that kind of stuff. If you have an issue you would like me to say something about a little further, feel free to name that as well in the question pane. Oh, someone just said, thank you so much, great information. Okay, it looks like we are maybe not going to have any more questions. And so what I'm going to do is, again, invite participants to have a look at the extra resources that I've put in Basecamp for this webinar. There are quite a few of them in there. Feel free to use them. And if you have any questions about their use or you want any additional information, I urge you either to write a message on the message board there or to contact the office or to email me on your own, and I'd be happy to provide any follow-up here. Okay, so I think we're going to bring this webinar to a close. Thank you all for attending today. I hope you found it valuable. And I'm just going to encourage all of our participants to attend next week when we are back to our normal time of, or normal date and time of Wednesday, February the 21st at 1:00 p.m. And David will be back for that 4th webinar. And the outline of his presentation will be in Basecamp early next week for you to look at. And the podcast of today's webinar will be available by noon tomorrow, also in Basecamp. Thank you all for attending.